Welcome, everybody. Thank you so much for joining us on this ASA webinar today. We're joined by Jeffrey Tenenbaum, who's going to guide us through some great conversations about the rapid changes that are affecting associations across our country. My name is Grant Carpenter. I serve as the Executive Director of ASA. We're so pleased to put on this webinar for you. So I will go ahead and introduce our facilitator for today. Jeffrey Tenenbaum is widely regarded as one of the nation's leading nonprofit attorneys. He's also an accomplished author, lecturer, commenter, and expert witness on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, Jeff consults his clients on a broad array of legal and sensitive business and governance issues affecting nonprofits. For 19 years, Jeff has practiced law at a national law firm in Washington, D.C., and has chaired his nonprofit practice for most of that time. Before welcoming Jeff, just a couple housekeeping notes. We do have the Q&A available. Please put any questions that you have into the Q&A. We will be sure to reference those at the end if time allows. We are in webinar mode, so you are able to raise your hand if you can, and you can talk to me through the webinar chat. But like I mentioned, please go ahead and put any questions into the Q&A section. So with that, Jeff, I will pass it off to you.
Thanks, Grant. And Grant, I'll rely on you or others to field the questions and pose them to me.
Absolutely.
Well, welcome to today's webinar, everyone. We have a lot to talk about in a short time today. Apologies for the distraction of my broken bookcase in the back when one of the little hooks on the side fell off this morning, and I haven't had a chance to fix it yet. Anyway, so we got a lot to talk about here today. What I'm going to try to do is probably spend about half the time, about 25-30 minutes, kind of covering a lot of the basics that I want to try to get through today on certain key areas to make sure everyone has the background, and then take the rest of the time answering your questions on a variety of different topics that we're going to be talking about. As Grant mentioned, I've been an attorney in Washington, D.C. for 30 years, all of it in private practice, all of it exclusively representing associations and nonprofit organizations. Founded Tenenbaum Law Group with my law partner Nisha 5.5 years ago. We're a 6-lawyer boutique firm in DC. All of our clients are associations and nonprofits. So all of the issues that I'm going to be talking about here today are issues that I've worked on for my whole career, and issues for which we are currently counseling hundreds of associations and nonprofits in this area to help them mitigate their risk, protect their tax-exempt status, and plenty else. So the topic of this session, associations under fire or nonprofits under fire, whatever we called it, is really an apt statement, because in the 3 decades that I've been practicing law and representing associations, I can't remember a time when at least it seemed like associations and nonprofits were under such siege. And I say seems because there have been a lot of threats that a lot of people have been concerned about that have not necessarily come to bear, at least not yet. And not yet is a very important caution here. But that being said, there certainly is a feeling like associations and nonprofits are under siege these days. And let's talk about some of the reasons why. And of course, as an attorney, I always like to focus on what are things that you can do to mitigate your risk. So first off, one of the biggest threats to nonprofits these days is for those nonprofits that receive or received federal funding, grants, cooperative agreements, or contracts. Now, most associations, which is this crowd, don't receive much federal funding. We have a number of clients, though, that are not associations, that are other nonprofits that do or did receive a lot of federal funding. And for a number of those in certain areas, the cuts to their funding have been massive and significant and caused tremendous harm to those. But I'm not going to focus on that today, because that's not really this audience. What I want to talk about is a few other key things where there's a lot of risk facing associations and nonprofits. A lot of it stems from DEI, diversity, equity, and inclusion initiatives, and a lot of people believe, that a lot of this scrutiny, this focus, these threats have come from this second Trump administration, and particularly 2 executive orders that were issued on January 20th and January 21st, kind of targeting DEI in some pretty significant ways, including targeting nonprofits that engage in kind of various DEI programs and initiatives. But really, the threat began kind of more in earnest about 2 years ago, actually almost exactly 2 years ago, June of 2023, when the U.S. Supreme Court issued its college admissions decision involving Harvard and the University of North Carolina, which essentially adopted a reverse discrimination kind of line of thinking that held essentially that it was illegal, both unconstitutional and in violation of federal law, to make race a kind of a positive factor in college admissions, basically ruling affirmative action programs and other kind of race-conscious college admissions programs to be illegal and unconstitutional. Now, that ruling only applied to college admissions, but what it essentially said was that if a college or a university is giving preference to someone based on certain protected characteristics, such as race, that in effect is discriminating against, in that case, white students and Asian American students. So that whole reverse discrimination rationale, which underlied that decision, pretty quickly started to get applied in litigation in other contexts, with the goal of getting a lot of these cases back to up to the U.S. Supreme Court. And sure enough, we've seen that happen over the last 2 years in two main areas. One is, and these are two big risk areas for associations. One is employment and one is contracts. And I'll explain what I mean by both. So in the employment setting, the law has been very much evolving in the employment setting, and it always takes years for the law to evolve, and eventually cases make their way to the U.S. Supreme Court. In fact, there's a couple this term that are going to be decided this month that many, including me, expect will kind of further reinforce this kind of reverse discrimination rationale in the employment setting. There was one case filed by a straight woman who was passed over for a promotion and then terminated in favor of two different gay women. The case is really about whether, if you're not a member of a protected class, like for instance, based on your sexual orientation, do you have a higher procedural burden to prove in order to prevail in the case, which has been the way the law has been for a number of years. It appears, based on the oral arguments, that the court is likely going to say no longer is that the case, and discrimination is discrimination, and there's no higher procedural bar just because you don't have certain protected characteristics. I expect we're going to see more and more of this. And so what we have been counseling our clients on the employment side is that if you have any programs, whether it's in hiring, especially in hiring, or in promotion, or in leadership acceleration, or anything that gives a preference to individuals in the employment setting based on their protected characteristics, there is a very strong chance that those activities, those initiatives in the employment setting may be discriminatory against people that don't have those protected characteristics, such as white people. And so what we have been counseling clients for at least the last couple of years now is to move away from any sort of race-based or other preferences in hiring and in the employment setting generally based on people's protected characteristics. That's an area of law that's enforced at the federal level by the EEOC and the U.S. Department of Labor. Every state in D.C. has their own Department of Labor, and of course, all of the federal and state employment laws can be enforced through private litigation, through aggrieved employees and whatnot. So it's a very high risk area. It's the #1 area of litigation against associations and nonprofits. And it's an area where if you're going to focus on your risk, it's a top area that you have to focus on. So I'd strongly encourage every association to look under the hood of your employment policies and practices, and try to root out anything that could give rise to significant risk in this area. The other big area of risk is in contracts. And here's what I mean by this. Most people are probably familiar with the Civil Rights Act of 1964, but there was actually an original Civil Rights Act in our country before that, in 1866. At the end of the Civil War, Congress enacted the original Civil Rights Act of 1866 in part to help protect the rights of the then freed slaves. And one of the things that Congress included in that law was a section of the law called Section 1981, which made it illegal to discriminate in contracting on the basis of race. For centuries, or as century plus. That provision of the original Civil Rights Act has been used by folks of protected characteristics based on race, such as African Americans, to bring litigation when they believe they were discriminated in contracting on the basis of race. But following the 2023 U.S. Supreme Court decision involving colleges and universities, the same gentleman who brought those lawsuits formed a new conservative nonprofit called the American Alliance for Equal Rights. His name is Ed Blum, BLUM. He formed this new nonprofit, which proceeded to bring a number of lawsuits against organizations that have both nonprofits and for-profits that have grant, scholarship, and fellowship programs that are limited to people of certain protected characteristics, including race. The rationale being that all of these programs involve a contract, and because eligibility for these grants, scholarships, and fellowships was in each case limited based on certain protected characteristics, including race, that it violated Section 1981 of the Civil Rights Act of 1866. One of those cases, which was brought against a nonprofit called the Fearless Fund, an Atlanta-based nonprofit that gave $20,000 grants to Black women-owned businesses, small businesses. That case actually got litigated to the 11th Circuit Federal Court of Appeals, which held that the plaintiffs had a substantial likelihood of prevailing on the merits. And they did confirm, the appellate court did confirm that while Fearless Fund was arguing that there were no contracts involved, they said, no, indeed, there was a contract. Even if it's an implied contract, there was still a contract involved in these grants. Ultimately, Fearless Fund decided to abandon their program and settle the case. But American Alliance for Equal Rights didn't stop there. They filed lawsuits against two big national law firms that had fellowship programs that were similarly limited based on race and other protected characteristics. They filed a lawsuit against the American Bar Association because of its scholarship programs, law school scholarship programs that were limited to people of certain protected characteristics, including race. They filed complaints with the IRS, claiming that the Bill and Melinda Gates Foundation and two other foundations should have their tax-exempt status revoked because they are engaged, because they offered in the Gates Foundation case, their signature college scholarship program was limited to people based on certain protected characteristics, including race. And American Alliance for Equal Rights alleged that that program, it was a significant program for the foundation, and because it was contrary, the allegation was because it was contrary to federal policy, that should make the foundation ineligible for 501c3 tax-exempt status. The Gates Foundation incidentally changed its criteria for its scholarship program a few days later after that complaint was filed, and they no longer limit eligibility based on race or other protected characteristics, but eligibility is simply based on financial need. They just substituted Pell Grant eligibility. So if you're eligible for a Pell Grant, you're eligible for the scholarship program. That's the federal assistance program for college students. Another conservative nonprofit called Do No Harm has brought lawsuits against other associations, such as the American Chemical Society. They also filed a complaint with the U.S. Department of Health and Human Services, Office of Civil Rights, alleging that a nonprofit called Academy Health should be investigated because of its scholarship program that was limited to people of certain protected characteristics. So you see where this is going. And there have been plenty of other both complaints lodged with federal agencies as well as lawsuits filed by both of these nonprofits and others. So it's going to be no surprise when I sit here and tell you that if your association or your related foundation has a scholarship or a grant or a fellowship program that's limited to people based on certain protected characteristics, including race, it's probably illegal. And you need to either abandon the program or, what most of our clients have done, change the eligibility criteria to something else, whether it becomes a need-based scholarship, whether you limit it to people in early stage of their career in a certain profession. There's lots of other ideas that we've given to clients of ways that you can modify your eligibility criteria for these grants and scholarships to kind of make them race neutral, but it's critical that you do that. And if you think you're going to be able to avoid liability by saying there's no contract involved, In my view, that's not a winning strategy. Um, to close the loop on the tax exemption issue, the editorial page editor for the Wall Street Journal wrote an editorial a couple months ago urging the IRS to pursue certain 501c3 organizations, to open up audits of certain 501c3 organizations that engage in activities that he believed were illegal, such as DEI initiatives, such as anti-Semitic activity, such as supporting immigrant rights, things like that, alleging that there's a 1980s U.S. Supreme Court decision involving Bob Jones University, which was or is a university that used to essentially engage in race discrimination in college admissions. They first banned Black students, and then later they banned any students that are involved in interracial marriages. The IRS pursued an audit and ultimately pursued revocation of exempt status for the organization, for the university, claiming that their activities were clearly contrary to well-established federal policy. Ultimately, the case, after about 10 years, went to the U.S. Supreme Court, which agreed with the IRS. And so that has been on the books ever since. There's never been another U.S. Supreme Court decision along those lines. But a lot of folks on the conservative right, including that Wall Street Journal editor, have been making the argument that if certain organizations are engaging in certain activities that they believe to be contrary to federal policy, that those organizations should be ineligible for tax exempt status. We don't know if the IRS is engaging in these audits. They're not allowed to say, even if they were. We don't know whether this would even be a plausible grounds for revoking exempt status. I tend to think not in most instances, although of course every case is going to be very fact specific. But I did write an article not too long ago, maybe a month ago or so, or a little longer than that, which I sent to Grant, which he's going to share with all of you. Something called like how the IRS can and cannot revoke the nonprofit's tax exempt status. And I wrote it particularly following a lot of the attention that Harvard University has gotten with threats to its exempt status from President Trump. And what I wanted to spell out in the article, which comes from a lot of experience over many years, representing about 75 tax exempt entities, primarily C3s and IRS audits, is that there's a whole process built in. If the IRS wants to revoke your exempt status, it cannot happen through an executive order. It can't happen from the stroke of a pen from the Treasury Secretary or the IRS Commissioner. There's a whole audit and appeals process that has a lot of rights built in for the exempt organization. And then there's ultimately court challenges available as well after that. And so I did not, there was a lot of concern in April. There's a lot, and Hester, I'll get to your question. There was a lot of concern in April that the White House was going to, via executive order, try to essentially remove the tax exempt status of certain categories of nonprofit organizations. That ultimately did not happen. The White House put out a statement saying it was never going to happen. Yet there's still a lot of concern about that. So I would encourage you, if you have any concerns about that, to take a look at that article and realize all of the protections that are there. Now, Hester, yes, you did hear me right, that if you have a scholarship program, whether it's through FSAE or a related foundation or otherwise, that is limited to people of certain protected characteristics, and one of those characteristics is race, then that program is likely illegal under Section 1981 of the original Civil Rights Act, and those criteria should be modified to substitute them with something else, or like some of our clients done, they just abandoned the programs altogether. A couple other areas of significant risk for associations. One is Congress. As most of you, I'm sure, know, there is a tax bill, a major reconciliation bill working its way through Congress. It has already passed the House. It's over on the Senate side now, where a lot of the key provisions are being negotiated. There was a lot of concern early on that the bill was going to contain some of the proposals from a gentleman named Scott Hodge, who for years ran the Tax Foundation, which is a kind of a right-leaning conservative think tank. The Tax Foundation had put out a bunch of proposals that would have effectively, among other things, gutted 501c6 tax exempt status effectively, basically made all income of tax-exempt organizations accept contributions and grants, taxable unrelated business income. Effectively, it would have pretty much done away with 501c6 organizations. Also proposed to cut back at a lot of the exemptions to unrelated business income for things like royalties and corporate sponsorships and convention and trade show revenue and investment income. In the end, none of those things were included, with one exception. There was a provision in the original draft of the bill that was passed by the House Ways and Means Committee that would have treated royalties that a nonprofit receives from the licensing of its name and logo as taxable unrelated business income. It would have removed the royalty exception for that category for name and logo licensing income. But ultimately, when that provision made it to the Rules Committee, it was stripped out by the House Rules Committee and was not in the final version that was passed by the House. There was also a provision that was disconcerting to a number of folks that would have allowed the Treasury Secretary to bypass the usual audit process in the event that there was an allegation that a nonprofit, a 501c3 organization, was supporting a terrorist organization. That provision was ultimately also stripped out by the House Rules Committee, I believe out of concern that it was going to violate the Byrd Rule when it got over to the Senate. So the major threats to associations do not exist in the House-passed version of the bill, but in the Senate, everything is up for grabs. There's a lot of debate and discussion going on. I don't think anyone believes that the House-passed bill is just going to pass the Senate. And so I know ASAE and others have been vigorously engaging in lobbying activity on the Hill, and I know we're doing so on the Senate side now. Hopefully you are participating in those efforts. But if nothing else, be sure that you pay close attention to what's going on, because there is certainly a lot of risk that provisions might work their way back in because they're revenue raisers, and the Senate is going to be looking for revenue raisers in the bill. And so keep an eye out for new threats to tax-exempt organizations, including associations. Two other things I want to briefly talk about. One is the states. Don't forget about the states. There are a lot of states, particularly politically red states, that are in the process of working through proposed legislation bills that are working their way through legislatures, as well as potential executive orders from red state governors targeting DEI and other things like that. That definitely, in some cases, would have a significant impact on associations and nonprofits. For instance, bills that would make it illegal to provide any diversity-related training to employees located in the state. Florida passed a similar bill a few years ago. That bill was challenged in court. It's currently on hold by a federal appellate court. It's enjoined. We'll have to see what happens there if that case makes it to the U.S. Supreme Court. But expect other states to enact similar bills. If you have remote employees or if you're based in one of these states, you're going to have to pay close attention to this. Things like that can most definitely have an impact on associations and nonprofits. So pay attention to state laws and executive orders in states which continue to evolve. And a lot of this is being kind of spurred on by the Trump administration. And it's something that you have to keep a close eye on. Finally, the other thing I want to highlight that we're seeing a lot in the association community are not legal threats, but threats, business threats, financial, reputational, coming from things like, these are all things that we've seen and heard from clients. Would-be attendees at a conference saying, we're not going to attend your conference if you still have that DEI track at your conference, or sponsors threatening to pull out their sponsorship because of certain actual or perceived DEI-related activities or initiatives of the organization. Exhibitors threatening to pull out, advertisers, sponsors, grantors threatening to pull their grant money because of certain DEI initiatives. It's a significant impact. We're certainly seeing this with federal employees saying we're not allowed to attend your conferences if there's any DEI content there. If you receive any federal funds, either directly or indirectly as like a subawardee, most recipients are having to certify under penalty of perjury that they do not engage in any illegal DEI activities. We don't know what illegal DEI activities are because they haven't been defined. We know from a lot of precedent that not all DEI related activities are illegal, not even close. But if you need to make such a certification, that's something you need to be very much aware of. I think we're going to continue to see more private litigation in this area, but just what a lot of our clients are doing, and we're probably up to about 36 reviews that we have done or are in the process of doing for various associations and nonprofits, where we've kind of been reviewing all of their DEI related activities and initiatives, trying to identify both legal and non-legal risk, and then making some suggestions for how to mitigate that risk. And some of these things are not illegal activities. For instance, if you have kind of DEI principles or concepts baked into your strategic plan, or baked into your key performance indicators, or baked into your board or committee selection criteria or things like that, they're not necessarily illegal. And one can make the argument with, if you had we have one client that has 2 designated board seats for people of certain protected characteristics, or at least it could be argued that that's the case. And because board members have to sign an agreement where they attest to comply with a conflict of interest policy and a confidentiality obligation and a code of conduct and copyright assignment, that's a contract. One could make the argument that potentially that's a violation of Section 1981. But even if it doesn't fall into that illegal category, a lot of associations where the DEI aspects of what they do is important to them, but it's not their core mission and focus, they're trying to dial back, or they are in the process. Some of our clients are dialing back some of these initiatives to try to make themselves less of a target, both legally and kind of from a business and financial and reputational perspective. I'm not sitting here telling you what you should do. We don't tell our clients what they should do. We're not telling you what's right or wrong. But what we are telling our clients is we're helping them identify what the risks are. We're helping give them ideas for how those risks can be mitigated, both the legal and the non-legal ones. And then we're telling them 2 other things, and this is what I want to kind of end on. 2 things that every association has to look in the mirror and figure out, and it's different in my experience for every association. One is, what's your risk tolerance? Every association has a different risk tolerance, and that risk tolerance changes over time, and it's generally defined by your board of directors. That's generally what, and that risk tolerance, of course, the board may define it differently today versus 2 years ago. But you really have to understand what your risk tolerance is. It's different for every organization, both legal and non-legal risks, such as business and financial and reputational risk, member relations, public relations. You really need to understand that before you can make decisions on what you want to do or not do, or change or not change. And then the other thing is, understand what your core values and principles are, and don't abandon them. And we have told this to every single client in every DEI memo that we've written, is don't abandon your core values. And while there may be certain things that you can do to mitigate your risk, some of it is fairly superficial, which a lot of associations have done, which is things like changing the name of your DEI committee to something else, changing the name of your health equity initiatives to something else. Like in the end, even one of the Trump executive orders talked about the fact, urging federal agencies to look beyond labels, and said that even if DEI gets relabeled something else, it might still constitute illegal DEI. I'm not suggesting that changing names is going to mitigate your legal risk. Probably won't, but it might make yourself a little less of a target. Look, there was a lot, we saw this in our client base as well. Back in the summer of 2020, about 5 years ago, there was kind of a pendulum swing after kind of the summer of George Floyd, where a lot of associations kind of swung pretty far to the left when it came to kind of integrating DEI principles and values and initiatives into their core activities, into much of what they do. Right now, what I'm seeing is a pendulum swing a little back, maybe not all the way back to the right, but back maybe toward the middle, recognizing the climate that we're in, the legal risk climate, the business risk climate, and trying to do things to help mitigate that risk. I'm not saying what you need to do or have to do or should do, not at all. I'm just telling you that these are real risks. These are things that your peer associations are looking at and are doing these days. And so I'm here today just to help flag these issues for you. All right, as promised, it's the bottom of the hour. Grant, I'm going to open it up. I know we had some questions, and feel free to bring them on for the next 30 minutes.
Absolutely. So we'll start with this first one. The question is, would training topics not be considered a free speech issue?
So first off, if you're talking about free speech in terms of the First Amendment. First Amendment only applies to government action. Um, some things, like I get this all the time, people raising First Amendment concerns about association activity, also raising, it's unrelated, but FOIA request issues with associations. Associations are private nonprofit organizations. Even like I said in my article, as a private nonprofit organization, even if the IRS revokes your tax exempt status, you're still a taxable nonprofit corporation. IRS can't take your money, they can't take your assets, they can't shut you down. Here, with respect to the First Amendment, it only applies to government action. So, and we're not talking about, now, if we were talking about the government trying to say what content you can and can't have at your conferences, would that be violative of the First Amendment? Possibly, because it's targeting speech. And a lot of the litigation that we're seeing from Harvard University and the law firms that have been, the big law firms that have been targeted, have been focused on those First Amendment issues, that it's a violation of the First Amendment for the federal government to go after folks based on their speech. And certainly, if that were the case, that is potentially a problem. But we're not necessarily seeing that, at least not so far. And there have been a lot of references in the Trump executive orders, and in Pam Bondi, Attorney General, wrote a memo about this, and in plenty of other proclamations referring to illegal DEI. But there's never been, to my knowledge, a definition of what sort of DEI initiatives are illegal in the eyes of the administration. And we're just simply not seeing the kind of, like enforcement actions based on content at conferences. But I think that itself probably would raise some First Amendment concerns. And so I actually, when I thought through the question, I realized that's kind of probably what you were getting at. But what we're also seeing is that this federal government is doing a lot of things that maybe are illegal. At least a lot of courts have said that a lot of the actions that the administration has taken are illegal. And so just because something might be violative of the First Amendment doesn't necessarily mean that it might not happen. And that's something that we have to keep an eye on. This is a lot of talk about that when it came to like the issues about, could the IRS just go out and revoke the exempt status of a whole swath of organizations without doing audits? Legally, they're not supposed to be able to. Congress can do it, but not the IRS without the audit and appeals process. But that doesn't mean that it might not happen, and that some folks are concerned about that.
Thank you, Jeff. Okay, we got a next question about international partners. So what about international partners pulling out of US-based events due to current administration policies?
We're seeing that all over the place. We're seeing international partners, whether it's attendees from foreign countries, whether it's partner, like the U.S. association has like a partner association over in the EU and the UK or elsewhere, not partnering up for a joint conference that they did, or a chapter, an international chapter, not sending its folks to a meeting that they usually attend. We're seeing that left and right. Because of the actions of the administration. We're also seeing a lot of associations decide to move their conferences that were previously held in the US overseas instead. These are more for like international organizations, associations. Yeah, that's one of the fallouts from this administration. And I don't know there's much that associations can do about it beyond the types of things that I'm just talking about. But it is a real risk. We have seen some of our clients try to do more things virtually as opposed to in person. But as we know from the early days of COVID, that's certainly not an ideal situation either. There's no silver bullet solution, but it's definitely a very real risk for sure.
Got another question here. Do you think organizations that have been vocal on opposing tax reform changes, for example, the SAEs that engage, should be nervous about possible vengeful activities from the powers that be?
It's something that everyone's talking about, that it's been reported that the administration kind of keeps an enemies list, so to speak. It's been denied by folks in the White House, but there's been some talk about that. I don't know if it's true or not. And that the organizations that tend to be highest on the enemies list are those that sue the administration. And that's different from engaging in like a lobbying coalition, to try to promote a tax bill that doesn't, gut tax exempt associations, things like that. I would not and who the hell knows if I'm saying has any credence or value to it, but I don't particularly think at all that should make you more of a target at all. This is just lobbying on tax legislation. There's people lobbying on every aspect of this bill on every side of the issue. What I'm going to pivot and say what I'm seeing more of is that a number of associations and nonprofits are choosing not to participate in litigation against the administration because there's a lot of opportunities. A lot of times people who are funding the litigation, they want to bring on associations and nonprofits as co-plaintiffs without charging them a dime because of who they represent and what that signifies. But we're seeing a lot of our clients who have had opportunities to do that beg off and say, no thanks, we don't want to make ourselves more of a target of the administration. I think that is probably more of a risk. And then, of course, particularly depends on the type of organization you are. But organizations, for instance, that do certain activities, like this is interesting. I pointed this out in the early part of that article about threats to tax-exempt status, and that is that there's been a program, I think, since the beginning of since the first Bush administration, called Public Service Loan Forgiveness, and it's a program that I don't know all the details, whether it forgives all of your student loans or part of your student loans if after school, I don't know if it's just undergrad or graduate as well, but after school, if you go to work for a government agency or a 501c3 tax-exempt nonprofit organization for a certain period of time, then your loans will be forgiven in part or in full. Again, I don't know the details. Well, the White House instructed the U.S. Department of Education to issue new regulations to say that no longer with this, you have to go through the whole regulation issuing process, which takes time. But once those regulations is presuming they get finalized, what they're going to say is no longer will all 501c3s be eligible for the Public Service Loan Forgiveness Program. And that certain organizations, including those that engage in illegal DEI, those that support anti-Semitism, those that support immigrants' rights, and there were a couple other categories which I referenced in the article, that those types of organizations will no longer be eligible for that program. To me, that's kind of a harbinger of where the IRS might go in the future. And you could imagine or envision perhaps the IRS defining, these terms that I said to you very broadly in a broader sense than maybe most of us would initially think about. And so I think those are some very real threats as well. I know I kind of went down a road with that answer, but hopefully that's helpful to you, because I think it's something to keep an eye on.
Yeah, thank you, Jeff. This is really helpful. I know so many of us sit on these webinars and we're not really told about any action steps. So even just the assess your risk tolerance and stick to your core values, those are two great action steps for us to take. Is there anything else? Oh, I just had one other pop in the Q&A here. Is geography included as a protective characteristic? For example, would a scholarship that is only awarded to African students be at risk? What about programs that award grants to students from underdeveloped countries?
Yeah, it's a good question, and there's probably some precedent on this, probably in the employment space that I'm just not familiar with. But what I do know is that even in the Justice Roberts majority decision that he wrote 2 years ago in the college admissions case, it talked about how it's illegal to take race into account as a plus factor in college admissions, but that you also cannot use other proxies for race. And so that's been something that's been focused on in the employment setting and in other settings and I actually did a webinar recently on this topic, and someone asked me, it's kind of analogous to this question, which is like, if you said that you're only eligible for scholarships, say it's in a particular city, like a citywide nonprofit, and you're only eligible if you reside in one of these 10 zip codes or 20 zip codes, whatever it is. And these are zip codes that are largely minority communities. That's something that could easily be construed as a proxy for race. So even though eligibility is technically not based on race, it could be a proxy. So I'm just trying to make an analogy, and that's a made up example, by the way. But certainly, if you're talking about underdeveloped countries, that doesn't necessarily have anything to do with race or other protected characteristics, but it could. And so I think it's the devil's going to be in the details. But what you want to be sure of is if something is illegal, whether it's generally only going to be in the employment front or in the contracting front, or if you receive federal funds. But if it's illegal, or we think it's likely to be illegal, to give some sort of preference or benefit, tangible benefit to someone based on certain protected characteristics, then you don't want to try to solve that issue by simply coming up with a proxy for that protected characteristic. But there are certainly ways to do it. Like, for instance, one of the things we've suggested to clients in kind of the practical suggestions for how you can modify your grant or scholarship criteria to not make them violative of Section 1981 would be to say that, among other criteria, that if you're a graduate of a historically Black college or university, you're eligible for the scholarship. And that's because historically Black colleges and universities do not exclude white student applicants. Now, again, could someone make an argument that that's a proxy for race? Who knows? I don't know. I don't know that that's been litigated, but these are the types of things that you're going to want to explore. And again, going back to core values and risk tolerance, right? If your risk tolerance, and look, most of these lawsuits, I'll be honest, the ones brought by American Alliance for Equal Rights and Do No Harm, they're demanding changes in the programs, and then they demand $1 in damages. So far, at least these two nonprofits are not seeking monetary damages. Now, granted, and maybe it's because they don't think they could prevail in court on the monetary damages that they'd have to prove. They are seeking their attorney's fees. And so lawsuits like this, that American Chemical Society got and American Bar Association got, no one wants to be hit with these lawsuits. The investigation that Academy Health got from Health and Human Services Office of Civil Rights, they didn't want to deal with that. And that, I'm saying that one because it was publicized. The agency leaked it to the Washington Examiner, which is something that we're seeing a lot of these days. No one wants to be a target of these suits, but at the end of the day, if you're willing to, like the Gates Foundation did, 3 days later, change your criteria, or like the Fearless Fund did, now, granted, they litigated for a while, but abandon their program or change your criteria. And if your risk tolerance is not that, if you have a decent risk tolerance, and that's not necessarily a bad thing if you want to stick to those core values. At the same time, if there are ways to change those criteria, or like in some of the other examples of non-legal risk, like if there are ways to, like some of our clients are eliminating their DEI committee, but they are still taking the core activities of that committee and baking it into the committee charters of other committees. Some are doing the same thing with larger organizations that have like a VP of DEI, which a number of organizations have, and a lot of them put those in place in the summer of 2020. Some are eliminating those positions, but again, baking in those responsibilities into other senior staff, like HR heads and people like that, but not abandoning the core values of what's most important to them. And you got to strike the right balance. And like I said, it's going to be different for every association. And like I've talked to a lot of boards about these issues. These are really board judgment calls. They're tough calls. And I've never had so many discussions with boards about these issues. I'm actually heading to New England next week for another board meeting where they want me there in person to talk through these issues, because they go to the core. These are going to be really painful discussions. And this particular client wants my perspective there in person. But these are tough judgment calls that really it comes down to the board to make. And you want to make sure your board is very informed of the legal and the non-legal risks, that they really understand what the risk tolerance of the organization is. Part of risk tolerance is also understanding what sort of insurance coverage do you have, and what sorts of, whether it's lawsuits, private lawsuits, or governmental investigations or governmental lawsuits, are going to be covered or not covered by like your directors and officers liability insurance and or your errors and omissions insurance. Understanding your insurance coverage is always important for understanding your risk tolerance, whether it's in the employment area or in the Section 1981 area, and then making sure you don't abandon your core values.
Well, thank you, Jeff. Like I mentioned, this is incredibly impactful to have actionable steps from this. Is there somewhere that our folks can get in touch with you after the fact? I did send out those links to your articles and different sections of your website for people to review the resources and news, but is there anywhere they can get in contact with you?
Yeah, well, first off, I sent 4 links to Grant that he shared with you. One is that article that I keep referencing about IRS revocation of exempt status. The other one is a an article about a lot of these DEI topics, although like one of my colleagues pointed out earlier today, it's these articles get out of date pretty quickly. And I think we wrote it like 2.5 months ago or something, and there's already been so many new developments. So it's not out of date and it's not wrong. It just doesn't reflect every new development. But on our site, I sent you a link to our publications page where we have all sorts of articles and presentations that we post, and we're constantly adding more. And similarly, there's a page with recordings that has primarily webinar recordings, including on these topics, and we're constantly adding more there. So feel free to check those. There's also a mailing list you can sign up for on our website if you want us to push those things out to you. And certainly my contact information is there on my bio if anyone wants to reach out.
Thank you, Jeff. We did have one more question pop into the chat, and we'll go ahead and answer it. What are the risks for associations that have or support supplier diversity programs, which encourage or have options for members that highlight, quote, minority-owned businesses or et cetera?
Yeah, that's a great one. So let me take a step back and give you a somewhat analogous situation, although it's certainly apples and oranges because we're talking about federal government. So last summer, last July, about 11 months ago, the U.S. Small Business Administration, which for decades operated, I think since the 70s, it operated this called Section 8A program. It was a federal contracting small business set-aside program that set aside and reserved certain federal contracts for minority and women-owned businesses. Those businesses that were 51% or more owned by minorities or women were eligible for this federal contract set-aside program, the Section 8A program. And the reason was that the SBA, the Small Business Administration, presumed that if you were minority or women-owned, that you were a disadvantaged business and therefore eligible for this program. Well, kind of seeing the writing on the wall, the Biden administration, Small Business Administration, got rid of those eligibility criteria. Those are now gone, and they're replaced with the fact that the application requires you to write like an essay showing how and why your company, your small business is disadvantaged. Now that's a federal program, and so federal programs have to comply, with the law, with the Constitution, in ways that private nonprofits don't have to. But and so in that situation, if you have some sort of, and we have actually some of our DEI reviews have looked at programs where, like in the selection of vendors, this is another kind of area where when I say DEI gets baked into like an association's operation and activities and programs, this is a good example of it. And we've seen it with some of our clients, like their procurement policy or their contracting policy, procurement policy saying that, just like a lot of associations have a procurement policy that says for anything you're going to procure over X thousands of dollars, that you have to do an RFP and get at least 3 bids and things like that. Well, some of these policies also say that there should be a preference given to minority-owned businesses and things like that. Or you have to get at least 1 bid from a minority-owned business. Or there should be preference given to minority-owned businesses in the procurement process. Are these things illegal? Potentially under Section 1981, yes, without question. Again, using that whole reverse discrimination line of thinking, if you're giving a contract, if you're letting, the term is let, it's a legal term, but if you're giving a contract to a minority-owned business to the detriment of, say, a white-owned business, folks like the American Alliance for Equal Rights and Do No Harm would almost certainly say that that is discrimination on the basis of race in contracting in violation of Section 1981. So in that particular example, I think it probably is illegal, and I would recommend changing those criteria. If on the other hand, I'll give you just another example of something that we see quite often. If you have in your nominating committee charter for your, that nominates people for your board, maybe even for committees, it encourages casting a wide net and trying to have as diverse a group of individuals on the board at any given time as possible. Is that illegal under any federal or state law, local law that I can point to? No, I can't see one. The employment laws don't apply there. There's no contracting involved. There's no quotas involved. It's just simply encouraging diversity in the board nomination and selection process. But could that make you more of a target for folks who don't agree with that particular line of thinking or think that board recruitment should be colorblind, potentially. And these are these tougher decisions that associations have to make that a lot of them are really grappling with, that are not necessarily the legal ones. Those are kind of the easy ones. And that's why, like in our memos, we deal with those first. We're like, you have no choice. You got to make these changes. That's the low hanging fruit. The tougher ones are the ones like this. So, long answer to a short question, but hopefully that's helpful to everyone.
That is helpful. One other one, can you clarify whether there will be a change to UBIT for associations, unrelated business income tax?
Yeah, so like I said earlier, I don't know if the questioner missed that part of it. There was a lot of proposed changes by Scott Hodge and the Tax Foundation to UBIT. Elimination of a lot of the UBIT exemptions like royalties, corporate sponsorships, investment income, trade show income. None of those made it into the House passed tax bill except one that would have eliminated the royalty exception for revenues received from the licensing of your name and logo. It was a provision that was, a lot of folks say, was targeting AARP, which makes a lot of money off of its logo licensing. That provision, though, while it was included in the version of the bill passed by the House Ways and Means Committee, it was stripped out by the House Rules Committee, reportedly because there were a number of nonprofits on the right side of the political aisle that were complaining that it was going to cost them, a good amount of money. And so they ended up stripping it out. And it wasn't a small revenue raiser, but it wasn't a massive one either. So that was the only proposed change. There is this other provision that is still in the bill, which who knows if it'll survive in the Senate side, which says that if you pay for parking or transportation like public transit for your employees, that the value of that in certain circumstances is going to be treated as unrelated business income. That's the only change. To me, it's not a tiny one. It will cost associations that provide those sort of benefits to their employees. It will cost them some unrelated business income. We don't know if it's going to survive in the Senate side or not, but that's the only change to UBIT that is in the House passed version of the bill. But like I said earlier, we don't know what's going to happen in the Senate. We know there's going to be a lot of changes. We also know there's going to be a lot of desire and pressure to put more revenue raisers into the bill. And so it's definitely worth keeping a very vigilant eye on. And I think everything's on the table.
Well, thank you, Jeff. That looks like that was all of the questions. So thank you so much for your time. Really appreciate it. People know how to get back in contact with you. I will reshare those links. This has been recorded, so I will go ahead and send this out after the fact. And then, Jeff, if you have any additional links, I can certainly pass it on to this group as well.
Great.
So thank you so much for your time, Jeff. Thank you, everybody, for attending. On behalf of ASA and all the state societies of association executives, we really appreciate it. And we look forward to seeing you on our next webinar. Thank you.
Thanks.